A Pittsburgh attorney is suing a judge, alleging that the judge overstepped his authority when he had the attorney arrested twice and forced the attorney to reveal confidential financial information and settle a civil matter pending before the judge. Let's have a look. In an article in the Pittsburgh Post-Gazette, Pittsburgh attorney sues judge for having him arrested and brought to court in chains for a civil suit. Walter Bernard, a black Pittsburgh lawyer and former NFL football player, said he was arrested May 3rd at his home, taken to an Allegheny County courtroom in shackles, and given 15 minutes to negotiate a civil lawsuit in order to regain his freedom. When Mr. Bernard didn't fulfill the judge's wishes, he got arrested again on August 9th for a bench warrant when he appeared in court to argue the same civil case. And this time, he was held behind bars for nearly 3 weeks. Mr. Bernard has filed a federal lawsuit against Allegheny County Common Pleas Court Judge Philip A. Ignelzi in the U.S. District Court for the Eastern District of Pennsylvania for multiple violations of his civil rights. Just a note, he did sue him in the Eastern District of Pennsylvania, but the case was transferred to the Western District of Pennsylvania. The judge has declined to comment through his judicial secretary. 2 days after his release from jail on August 28th, Mr. Bernard recalled how he was arrested on his birthday in front of his Pine Township neighbors, placed in back of a marked police car, taken to a jail cell, and then shackled and led through the hallways of the same county courthouse where he represents criminal defendants. Once in Judge Ignelzi's courtroom, Mr. Bernard said he was given only 2 options if he wanted to gain freedom from his shackles, and he only had 15 minutes to make the choice. He could settle a pending civil lawsuit on behalf of himself and his client, his brother Wynton Bernard, with no ability to negotiate the specific settlement terms, or he could relinquish bank statements and tax records, which Mr. Bernard asserts are protected documents for a matter pending before the appellate court. So, just so that we understand what's going on here, and the civil suit actually gets into all of this, but the civil complaint is a little long, so I'm going to summarize it for you. Essentially, Walter Bernard, the attorney, was involved in a business that he and his brother owned. During the COVID pandemic, the business saw a decrease in volume of its customers to 0, and as a result could not pay the rent on the facility that they were renting to run the business. The landlord sued them, and they were arguing over a specific provision in the lease agreement. Well, the original judge on the case settled that dispute and found in favor of the landlord. So he ordered that Mr. Bernard pay the remaining term of the lease agreement. However, the landlord had already released the premises, so the judge didn't finally execute an order determining an amount of damages because he said that there should be a credit applied for the rent that the new tenant was paying. That amount had yet to be determined. So essentially, the judgment was non-executory, meaning that the landlord could not collect on the judgment because there was no amount for them to collect. According to Mr. Bernard, in Pennsylvania, when a judgment is non-executory, the plaintiff cannot gain discovery in aid of execution because they have nothing to execute. However, the landlord sought discovery in the matter, and it was that discovery that Mr. Bernard was withholding. The judge ordered him to produce the discovery, and he appealed that decision. So that's where we're going to pick up in this particular civil case. And to basically understand what they're alleging here, we are going to look at the Pennsylvania Rules of Civil Procedure. Under the Pennsylvania Rules of Civil Procedure, the filing of an appeal divests the trial court of jurisdiction to proceed further in the matter. Also, under the rule, when a party has appealed from a collateral order, so that's an order appealing a non-final judgment. So in this case, it's a discovery order, it's non-final, and so it doesn't fully divest the trial court of jurisdiction over the entire matter as an appeal of a final judgment would. Instead, the trial court retains jurisdiction to continue to act on those parts of the case that are unrelated to the collateral matter that is the subject of the appeal. So essentially what the attorney here is saying is that under the rules of civil procedure, when I appealed the discovery ruling, the court no longer retained jurisdiction to make any rulings or do anything with respect to that discovery ruling. But that doesn't appear to be what happened according to this complaint. So at some point, another judge ended up on the case. And the complaint doesn't tell us how this other judge ended up appearing on the complaint or in the case, but it's that second judge who the attorney is taking issue with. Now, when the matter was originally decided by the original judge, the judge entered an order that said that the judge retained jurisdiction over the case, which means that this second judge shouldn't have had jurisdiction in the first place. But unfortunately, the complaint doesn't get into how this judge got involved, but we know that he did. On Wednesday, May 3rd, 2023, at approximately 8 a.m. on Attorney Bernard's birthday, Judge Ignelzi, this is the second judge, upon information and belief, directed sheriff officers to take action which caused a severe disturbance within plaintiff's neighborhood. Neighbors witnessed approximately 6 law enforcement deputies from the Allegheny County Sheriff's Department yelling and banging on plaintiff's residence, causing neighbors to witness the commotion. Sheriffs continued to bang on plaintiff's front door, windows, and back door continuously for approximately 1 hour. Sheriffs even threatened Attorney Bernard that they were going to break into the premises. At or around 8:56 a.m., one of the sheriff's officers called Attorney Bernard on his personal cell phone and left a voice message demanding that Attorney Bernard open the door, because if the behavior of not opening the door continued, that he was going to jail. Attorney Bernard called the sheriff back immediately, and the sheriff indicated that Judge Ignelzi just wanted to see him. The sheriff also threatened that if the Attorney Bernard didn't come out, the situation was going to get much worse. Under the threat of armed officers breaking into plaintiff's residence with a break-in order from Judge Ignelzi and being concerned for his family's safety, Attorney Bernard came outside of his front door. Attorney Bernard was arrested and escorted to the back seat of the sheriff's vehicle while neighbors continued to witness a black attorney being taken away by multiple law enforcement agents. Attorney Bernard was transported downtown to the Allegheny County Sheriff's Department, where he was removed from the vehicle and shackled. Next, he was placed into a large prison jail cell with other inmates, also known as the bullpen. Contained within the jail cell with Attorney Bernard were approximately 5 other prisoners. Since Attorney Bernard was seized early in the morning, he didn't have a chance to eat breakfast and remained in the jail cell hungry with no food. After being incarcerated for hours, he was eventually summoned to come out of the jail and was reshackled. Attorney Bernard was then escorted in shackles through the Criminal Court of Common Pleas of Allegheny County, where he represents criminal defendants. While still in shackles, Attorney Bernard was brought before Judge Ignelzi and was ridiculed for not opening his residential door quickly enough for the numerous deputies as they knocked outside. Additionally, Judge Ignelzi scorned and blamed Attorney Bernard for almost getting himself hurt. He also scorned and reprimanded Attorney Bernard for potentially causing harm to the sheriff deputies. Judge Ignelzi confirmed that there were discussions with the sheriff's department that an approval of a break-in order into plaintiff's residence almost occurred. While Attorney Bernard remained in shackles in the courtroom, Judge Ignelzi gave Attorney Bernard an ultimatum consisting of 2 options to be decided within 15 minutes in order to be free from incarceration. Attorney Bernard needed to settle the case that was currently on appeal before the appellate court in an amount that the opposing counsel had predetermined, with no ability to negotiate without his client being present. Or 2, that Attorney Bernard was required to disclose the confidential information from both his and his client Winton Bernard's private information. Judge Ignelzi made it clear that if Attorney Bernard did not agree to one of these 2 options within 15 minutes, Attorney Bernard would remain incarcerated. While remaining under duress, Attorney Bernard began involuntarily answering questions. Judge Ignelzi continued to threaten Attorney Bernard that if he did not respond with answers to his liking, or if the answers were not sufficient, he was going to order that Attorney Bernard remain in the custody of the Allegheny County Jail. At one point during the interrogation, Attorney Bernard pleaded with Judge Ignelzi that his actions were unjust and unconstitutional. However, Judge Ignelzi responded with, "You may not like it, but it is very just." Judge Ignelzi continually mandated Attorney Bernard to answer questions in full without allowing Attorney Bernard to object to any of the questions. For example, when Attorney Bernard attempted to object to the relevance of answering questions pertaining to his 2018 income because the matter in dispute arose from events that occurred in 2020, Judge Ignelzi said, "No, we're past that." Judge Ignelzi made Attorney Bernard answer questions against his will, and after Attorney Bernard would answer, he would then look at opposing counsel in the courtroom and confirm if the answers were good enough. Once opposing counsel verbally confirmed that answers were sufficient enough, Judge Ignelzi would proceed to the next question. Judge Ignelzi finally allowed Attorney Bernard to be released from custody on condition that plaintiffs produce all information and that opposing counsel was going to subsequently draft up and request. Judge Ignelzi then gave opposing counsel assurance that whatever was drafted, he would approve prior to seeing the order. Now, there's a multitude of problems here. But before we get into the problems, this complaint was filed on August 12th. Attorney Bernard was arrested the second time on August 8th. His second arrest apparently stems from his failure to provide the documentary evidence of the financial information that he was ordered to produce by Judge Ignelzi in order to be freed of his initial incarceration. So essentially, what Attorney Bernard is alleging is that this judge made orders, rendered orders that went against the rules of procedure in Pennsylvania, but further, that he, in violation of those rules, had Attorney Bernard arrested and subsequently forced him under threat of duress and further incarceration to reveal confidential information and essentially to settle or to essentially settle a lawsuit that which his client was not present. Now, the second time he was arrested, he was forced to settle the lawsuit according to the article we just read. He was forced to settle the lawsuit and even went so far as to cut a check for $80,000 to the landlord. And even after he cut that check, while in jail, he remained in jail for another week thereafter. So I anticipate that this complaint is going to be amended to include the additional allegations against the judge and or others because of the second incarceration and the forced compliance with extrajudicial orders that arise out of this action. So Attorney Bernard is suing the judge here for several things. He's got Fourth Amendment violations for unlawful seizure. Essentially, he's asserting that Judge Ignelzi seized information from him under the threat of duress and incarceration when he forced him to answer those questions regarding matters that were already up on appeal. He's got a second count here for unlawful search, which is essentially the same thing. He's saying you searched for this information in violation of the law. A third count for deprivation of liberty without due process. He's basically saying, look, you had these officers come to my home and arrest me without a warrant, without any criminal charge whatsoever, without any indicia that Attorney Bernard had violated any criminal law or committed any criminal infraction. So without any type of due process, he was not only arrested, but then he was forced to essentially pay the punishment for the crime that he never committed by the judge forcing him to reveal information that was up on appeal. He's got another count for violation of substantive due process, which is a little more nebulous of a claim under our current Supreme Court precedent, but it's essentially a right to privacy thing under the 14th Amendment, things of that nature. Essentially, he's got multiple counts here. He's alleging discrimination. He's alleging right to counsel. He wasn't afforded the right to counsel when he was deprived of his liberty. So essentially, Attorney Bernard is alleging a great deal of judicial misconduct against this judge. He's doing so in federal court. And if the allegations in this complaint are correct, it does look like the judge engaged in judicial misconduct. Now, he's got some discrimination claims in here. I don't know whether or not he's going to be able to meet the threshold for discrimination, but based on these allegations, it looks like the judge has got a serious problem on his hands. Let me know what you think in the comments below. My name is Nathan Saunders. This is The Legal Good.